Welcome to the Max Future Weekly Podcast. All Apple talk and no chit chat.
Okay, welcome to the Apple Podcast, episode 124. This is Sunday, August 5th, 2012, and we got a lot of stuff to talk about. This is a chit-chat-free podcast all about Apple, Apple news, Apple products, Apple stuff. And it's I try to come out on a weekly basis, and you can support this podcast by going into iTunes and giving it a positive review. That's all I ask for. There's no advertising on the audio feed of this. I have a video version of this just with screenshots of the stories I might be talking about. And that one gets some YouTube ads, but nothing big. So anyway, thanks for listening, and let's get to it. Episode 124. Okay, so the first thing I want to talk about is that this week, this past week has been really big news that Apple has its trial against Samsung. It's a big jury trial, and it started last Monday, and it's been quite an intense trial. And basically, Apple is alleging that Samsung violated various patents, including patents involving the design of the iPhone and the iPad, the shape of the iPhone and iPad. I guess also some technical patents regarding how you use the iPhone, iOS, and that sort of thing. And Samsung countersued, alleging violations of what are known as FRAND patents. These are patents that Samsung, like other tech companies, when they create stuff and they want other people to use them, they say, look, we're going to make this a standard so we can, interchange and use each other's stuff. So, for example, when cell phones came out, obviously wanted one cell phone to be able to talk to another cell phone. So the technology that, was 3G technology, basically the people created say, we're going to make this a standard. And because it's a standard, we're going to make it easy for anybody to license cheaply. And those are known as FRAND patents, fair and reasonable, I guess, is what F&R stands for in terms of licensing. And you promise to license it because you want people to adopt your technology. Well, Samsung, not having enough cards to play in defending itself against Apple, countersued Apple, alleging that Apple won't license or hasn't licensed certain 3G technology. And Apple's saying, yeah, we tried to license it, but Samsung is charging us so much money because they're trying to deter us from suing them on non-FRAND patents. So that's what the lawsuit's about, and there's a lot at stake. Apple is seeking $2.5 billion in damages. That includes, I think, treble damages. In other words, Apple comes out with an estimate of how much money it's lost because Samsung has copied Apple. And then I think they get some sort of trebling of damages, where the jury can say, look, it was willful, so Samsung has to pay extra. And that's how they come up with $2.5 billion. So it's been really a crazy, crazy trial in the sense that there's a lot of fireworks. And it's almost like Samsung's attorneys are trying to purposely upset the judge. And so let me give you a recap of what happened that's been the most interesting. So after they picked the jury on Monday, Samsung's lawyer from the law firm of Quinn Emanuel, he tried to get to re-argue before the judge, something that was previously argued and which Samsung lost several times. And, in a way, he got the judge very upset. Now, over at Alison Frankel's column on the case on Thomas Reuters news service, she really has a great article on August 1st, 2012, which really captures what Samsung's lawyer, John Quinn, did that day. That was really kind of crazy and seemed to really, piss off the judge. And Alison Frankel writes, what was John Quinn thinking when he authorized a press statement on behalf of his client Samsung? So let's give the backdrop what the issue was. Basically, Judge Koh handed down before the trial evidentiary rulings on limine motions for and against both sides. And what Samsung was very upset about was was something that the judge ruled against were what slides Samsung could present to the jury during Quinn Emanuel Partners Charles Verhoeven's opening statement. And Samsung wanted to display images of Samsung designs that were in development, Samsung claims, before the iPhone, which looked similar to the Apple product and could undermine the validity of Apple's patents. And also Samsung wanted to discuss evidence that Apple relied on Sony phone designs to show that even Apple is inspired by others. But apparently before the trial, United States Magistrate Paul Grewal ruled that Samsung hadn't disclosed, I guess in discovery, those contentions in time. So Judge Koh, who is the district judge presiding over this thing, said that Samsung couldn't use them during the opening statements. Now, Judge Koh is, I think, Korean-American, which is interesting because some people who are Android fans are saying she's biased in Apple's favor, and she's ruled many times against Apple in this case. And in fact, Apple had to appeal to the circuit court to get her overturned on a previous decision. So, and this is a common thing, you've got to disclose, in civil court in the United States, in federal court, you can't have trial by ambush. You've got to disclose everything during the discovery process and during the pretrial process. So, apparently Samsung wanted to use slides of some phone, but they haven't, they didn't raise this in their contentions and their defenses earlier, so that you can't at the 11th hour suddenly change your story and have other defenses. So apparently on Tuesday, after the trial had started and after the jury was sworn in, and just minutes before the openings were to start, John Quinn, who's the senior managing partner, I guess, of Quinn Emanuel, a major American law firm, he stood up, and Frankel here has a very interesting description. She says, dressed in a stylish blue suit with mussed hair, Quinn stood before Koh and said he had, quote, been practicing for 36 years, end quote, and had never begged the court, but that now he was begging that she reconsider on the slides. And again, Judge Koh said no. This is when, according to Frankel, Quinn said the following. He sort of raised his voice and he said, "What's the point of having a trial?" Rhetorically, question mark. What's the point? And apparently Judge Koh tried to shut him down and said, Mr. Quinn, please, we have done 3 reconsiderations on this. You've made your record, end quote. And then Quinn goes, can I get some explanation? And the judge says, Mr. Quinn, don't make me sanction you, please, the judge barked. I want you to sit down, please. So, even just that alone is kind of outrageous because, in a jury trial, you do not want to upset the judge because you want the judge to be on your side, because the judge is going to make rulings and going to give instructions to the jurors, and the jurors are going to look to the judge, and if the judge looks annoyed with you as an attorney, the jury is going to think you're not a good attorney, and that could affect your case. So, but this is when things got really crazy. So after the openings were done, at about 2:48 p.m., I guess, Pacific time, and while a Apple industrial designer was testifying, a Samsung press statement hit the press boxes of various major press outlets, including Reuters, and it included a link to the excluded slides. And the press statement from Samsung said the excluded evidence would have established beyond doubt that Samsung did not copy the iPhone design, the statement said. Fundamental fairness requires that the jury decide the case based on all the evidence. So this is pretty crazy because, the jury is already sitting, and it's not like a murder trial where they're told they can't go outside and are locked up somewhere. No, the juries can go home. They're told not to, go on the internet, But this is all over the internet when you, Samsung, send this around. So less than 2 hours later, according to this Reuters account, after Judge Koh sent the jury home for the day, Apple's attorneys from the law firm of Morrison Foster stood up and said that they had been unsure of what Quinn was up to that morning, but the press statement made it clear. And what Apple's attorneys from Morrison Foster said was, quote, "This is an intentional attempt to pollute this jury," end quote. And the partner from the law firm representing Apple, said that it should be considered, quote, "contempt of the court," end quote. And according to Reuters, Judge Koh jumped all over it and said, "Call Mr. Quinn," she told the Samsung legal team, end quote. I'd like to see him today, end quote. So then Samsung's team told the judge that he, Mr. Quinn, had gone back to Los Angeles for an event. So the judge, then ordered Quinn to file a declaration by Wednesday. And she wrote, quote, "I want to know who drafted the press release, who authorized it from your legal team," end quote. "And I want Mr. Quinn's declaration as to what his role was." So this was really a big deal, because it looked like, that Samsung was purposely, its lawyers may have been trying to influence the jury with evidence that the judge had excluded by sort of sending it out there on the internet for all to see. So, this is a really big issue, and I don't think that's a good sign for Samsung, that they're sort of infuriating the judge so much. Now, you should know there is something else that Samsung had done that also counts against it in the trial, and that is that at the end of last week, the magistrate judge in the case ruled that Samsung had engaged in spoliation. And I posted about this. And what is spoliation? Spoliation is if you purposely if you wrongfully allow evidence to be destroyed because you know you're going to be sued or you're going to be in litigation. Now, in federal court, in civil cases like this, there's something known as discovery. And discovery means either party can make requests that the other produce documents or emails or whatever records that could be in any way relevant to the case. And the parties get wide discovery rights, so they can get a lot of material to try to find evidence that could help them. And Apple alleged that Samsung, in advance of the litigation, allowed some of its evidence to be destroyed. And this is not a good thing. And so there was a motion practice before the trial, and basically the bottom line is this. This is what happened. Apple, in the summer of 2010, communicated to Samsung that it believed Samsung was violating its patents and other intellectual property with the development of, the Galaxy line of phones and iPad and tablet. And at the time, Samsung had an email system from the vast majority of its employees that automatically deleted emails that were 2 weeks old. This was some sort of proprietary email system that Samsung had. And, Samsung is huge like Apple and has thousands and thousands of employees. But at the time, Samsung's legal department sent a message to like 14 employees saying something to the extent of, hey, we could be sued by Apple, and we're going to take steps so that, your email is not destroyed and things are saved, because we might have to produce them in discovery if we're ever sued. Something like that. But Samsung didn't send that out to a broader number of employees in the summer of 2010. And it wasn't until the spring of 2011, when Apple actually sued Samsung, that Samsung took steps to prevent emails from being destroyed from employees beyond the 14. And there were a lot of employees beyond the 14 who got the notice from Samsung's legal department in the summer of 2010. And a lot of them ended up being important witnesses for Apple in discovery and in this case, but they didn't have relevant emails because they were destroyed. So this was a pretty devastating ruling that the magistrate handed down. So the judge in the case, the magistrate judge, basically found that Samsung had engaged in spoliation, which in other words, allowing evidence to be destroyed. And so the remedy that the judge decided to impose is an inference instruction that the jury is going to get in the trial. And here's what the magistrate judge wrote, which was then adopted by the judge. This is the instruction that the jury is going to get. Quote, Samsung has failed to prevent the destruction of relevant evidence for Apple's use in this litigation. This is known as spoliation of evidence. And then it goes on to say, I instruct you as a matter of law that Samsung failed to preserve evidence after its duty to preserve arose. This failure resulted from its failure to perform its discovery obligations. You may also presume that Apple has met its burden of proving the following two elements by a preponderance of the evidence. First, that relevant evidence was destroyed after the duty to preserve arose. And two, evidence is relevant if it would have clarified a fact at issue in the trial and otherwise would naturally have been introduced into evidence. And second, the lost evidence was favorable to Apple. And then it goes on, the instruction would say, whether this finding is important to you in reaching a verdict in this case is for you to decide. You may choose to find it determinative, somewhat determinative, or not at all determinative in reaching your verdict. So basically, already, even with this other fiasco involving the issuing the press release about the exhibits and upsetting the judge, Samsung got this bad ruling which says that the jury is going to be told that relevant evidence was destroyed after the duty to preserve arose, and that the lost evidence was favorable to Apple. So that's, I think that's a pretty big handicap for Samsung in this lawsuit to get that instruction, because the jury's going to think that Samsung was up to something sneaky by allowing evidence to be destroyed. What else? So let's go back to the issue of what happened to the Samsung releasing those exhibits. Okay, so then on Wednesday, Samsung's attorney Quinn submitted a declaration, and he wrote the following, something like this. He said, contrary to the representations Apple's counsel made to this court, Samsung did not issue a general press release, and more importantly, did not violate any court order or any legal or ethical standards, end quote. He wrote, quote, these false representations by Apple's counsel publicly and unfairly called my personal reputation into question and have resulted in media reports likewise falsely impugning me personally, end quote. And then he claimed that that Samsung was just merely responding to press inquiries about the issue. And then Frankel notes that she never, asked them about it, and so the email she got was unsolicited. And apparently, Samsung attached a redacted email that Quinn said they got from a journalist, and Quinn, Samsung's lawyer, argued that all the excluded exhibits were previously in the public record, and that lawyers have a First Amendment right to speak to the press. And then it goes on to say that the case has enormous potential commercial impact. And Quinn said, quote, Samsung's brief statements and transmission of public materials in response to press inquiries was not motivated by or designed to influence jurors, end quote, Quinn said. He said, quote, the members of the jury had already been selected at the time of the statement and transmission of these public exhibits and had been specifically instructed not to read any form of media relating to this case, end quote. Now, I guess, he's basically was saying that Samsung didn't do anything wrong. Then on Wednesday, Apple said that Quinn had not answered all of the judge's questions, and it would file an emergency motion seeking sanctions. And Apple did that, and among the sanctions Apple was seeking was that the court declare certain of the patents that Apple was litigating and claiming that Samsung violated as being valid and enforceable, which would, or alternatively some sort of inference that the jurors should draw from the conduct. And instead, on Friday, what the judge did was, the judge said that she was going to reserve, handling what the lawyers for Samsung had done till maybe after the trial. So who knows what she's going to do to them after the trial. But in terms of, she didn't give Apple the sanctions against Samsung that Apple wanted. Instead, she called out each juror individually and essentially asked them if they had seen any press reports, that could be anything about those exhibits and such. And she seemed satisfied that the jurors had not seen anything. And so now, still what Samsung did isn't going to help them because they obviously, Samsung's lawyers pissed off the judge, and the judge is going to be sort of skeptical of a lot of what Samsung's lawyers are doing in court. And also the judge could still maybe make findings after the trial that Samsung's attorneys engaged in conduct that was improper and sanction them, which would be pretty devastating. So that was a big drama last week, but there's other stuff that came out that was very interesting too. Okay, so now what's funny about what Samsung was trying to do in terms of the slides is that I don't really even think what it was trying to do was that effective. These slides are not really effective. The main slide that Samsung was trying to get in was a picture of the F700 phone that Samsung was developing. And I guess the main reason, Samsung wanted to get this into its opening argument to the jury was to argue that, Samsung didn't copy Apple. Samsung copied, or had its own design. But the thing is, the F700 really doesn't look anything like an iPhone. So I think it's kind of bogus for Samsung to try to argue that. Now, Nilay Patel of TheVerge.com, he had a really great post a long time ago pointing out that the F700 is not really a defense for Samsung. And then he, back in April 20th, in an article entitled, "Let's Talk About This Picture of a Samsung F700 Phone." And so he says, and I have a picture of the F700 phone, if you're looking at the video podcast of this, and he says, so this very funny picture of the F700 in the original iPhone is like the LOL cat companion to my Apple Samsung lawsuit analysis from yesterday. Apparently a lot of people were tweeting the front view of this phone to show that Samsung didn't copy the iPhone. But what Patel said is, I'm seeing it everywhere, and it's been sent to me several times. He goes, unfortunately, it's also factually inaccurate. The F700 was announced in February 2007 at Mobile World Congress after the iPhone was announced in January at Macworld, and it's actually, according to Nilay Patel, a chunky 16.4 millimeter thick slider QWERTY keyboard phone that looks appreciably different than the iPhone. And he goes on to say it also has a home screen that's quite different than Apple's iOS. And he says, that basically there's a function menu, and there are no apps on it. It's just a dumb phone. And, the differences are really huge because basically a gigantic keyboard slides out of the back of it. And as Patel points out, these aren't just minor differences. They combine to create an entire user experience that's instantly and recognizably different than an Apple or iOS product. In many ways, the F700 does nothing but underline Apple's overall contention that there are thousands of ways to design and package a phone interface, but Samsung chose to drop its differentiated interface and instead lift elements of Apple style for TouchWiz. So it's kind of crazy that Samsung is, if this is their defense, if this is the thing they so desperately tried to get into the trial that they think is going to save them, they're kind of nuts, because the Samsung F700 really doesn't look anything like an iPhone, other than maybe be a little bit of a rectangular shape, but it has a gigantic QWERTY keyboard coming out. So it's kind of a bogus defense. Now, Apple's argument and the slides it shows, I thought were very powerful. Basically, Apple was trying to argue, like, look what Samsung's phones were like in 2006 or prior to 2007, before Apple announced the iPhone on January 9th, 2007. And then look and see what they're like now. And if you just look at them, Apple says, look how much Samsung changed its phones to look like the iPhone. So if you're looking at the video version of this, I have like one slide that Apple showed, and you can see, on the left, it's showing the Samsung phones like the i700, the i730, the i830, and the Blackjack 1607, which all came out between, let's say, 2004 and November 2006. And they don't look anything like the iPhone that was announced on January 9th, 2007. And, so that slide, I think, is very, very, very powerful for Apple. And, I think a lot of a case comes down to the simplicity of the argument, and I think this is very powerful. Okay, so then on its chart, Apple showed, the iPhone, if you're looking at the picture of this, that came out on January 9th, 2007, and then the Samsung phones that came out after the iPhone, like right after the iPhone came out. And they started evolving, starting to look a little more like the iPhone, but they were still, significantly different. And listed there are phones like the i850 Innovate, the i8910 Omnia HD, which came out in May 2009, the M7600 Beat DJ, which came out in May 2009, the Jet 5 8000, which came out in June 2009, and the i5 700 Galaxy Specca, which came out in November 2009, and the Sunburst, which came out in March 2010, and they all still look very different than the iPhone. But we'll see, things are going to change. So then the third slide, or the third part of the slide, Apple shows the more recent Samsung phones compared to the original iPhone, and all of a sudden they all look like the iPhone. They're all that same, rectangular with the rounded curves, all of them. So, in this slide, you've got the Apple iPhone announced on January 9th, 2007. Then you have the Galaxy S19000 that came out in June 2010. The Vibrant T959, which came out in July 2010. The Mesmerize, the i500, which came out October 2010. The Galaxy S4G, which came out in February 2011, and the Galaxy S2. So when you look at these slides, it looks like Apple's making a very powerful argument that Samsung suddenly changed its phones to look like the iPhone in the look and feel. So, I think it's a pretty compelling argument. Now, the press has been having a field day with this trial because, because of the discovery process, both sides get, to get a lot of information internally from each other's company. So Samsung has gotten a lot of data, or its lawyers have gotten a lot of data internally from Apple, and vice versa, Apple of Samsung. And some of the stuff has been made public, and now you have prominent Apple executives testifying, and a lot of stuff that the public didn't know about is becoming public. And so, for example, over at All Things Digital, Mike Isaac, he had a nice article, 5 Things We Learned at the Apple-Samsung Trial Last Week, and he points out some of the interesting stuff that came out. So here's some of the more interesting stuff. So Eddie Q, who's a big executive there, he apparently liked the idea of a 7-inch iPad at some point, and he apparently, emailed or tried to sell it to Steve Jobs. And so there was an internal email revealed in the trial where he wrote, quote, "I believe there will be a 7-inch market and we should do one," end quote, Q wrote, going on to state that the now deceased Jobs even, quote, "seemed very receptive," end quote, after Q mentioned it to Jobs several times. So he sent this email back in 2000 and I guess 11. So in other words, Apple executives are moving towards releasing a 7-inch iPad. And why is this interesting? Because back in 2010, I think it was in October, Steve Jobs joined an analyst conference call that Apple was having and said that he railed against the smaller tablets that were coming out, and he said, quote, "It's because we think the screen is too small to express the software." And at the time, I remember Steve Jobs said, people would have to file their fingers to, to use a 7-inch tablet. But now we're seeing multiple, reports that a 7-inch or an 8-inch tablet is going to come out from Apple. Now, All Things D in this article also reported the other information coming from the trial. Apparently, the iPhone development and how it was done, it was internally called Project Purple. And it was way back in 2004 that Steve Jobs basically asked Scott Forstall to oversee this gigantic internal project to develop secretly the iPhone. And apparently Forstall testified that Steve Jobs gave him carte blanche to recruit any member of Apple's engineering staff for Project Purple. He couldn't hire anybody outside of Apple because they wanted to keep it secret. And also Forstall could tell them virtually nothing about the project, save for the fact that they'd be giving up nights and weekends for the next few years. And apparently they secured like a building and took over an entire floor. And I think they put up like a Fight Club poster from the movie Fight Club, because the idea being anything that happens in there could not get out. Because I think in the movie Fight Club, everybody who was in the Fight Club agreed not to talk of it outside the Fight Club. So that was a colorful bit of information. He also reported, this is Mike Isaac on All Things D, he reported that, Apple designs its products at a kitchen table. So Chris Stringer, who was the first witness Apple called, who's a veteran Apple designer, he basically testified that the company's entire product portfolio stems from a group of 15 or 16 people who are, designers and who convene around a kitchen table to discuss the exhaustive, laborious design process behind each device. And Stringer testified, "We'll sit there with our sketchbook and trade ideas," end quote. Quote, "That's where the really hard, brutal, honest criticism comes in," end quote. Okay, so that's interesting. He also said even Steve Jobs doubted the iPhones at time. Stringer testified that Steve Jobs had doubts that it would ever see the light of day. And Stringer from Apple testified smartphones existed, but they were more like little computers. We were doing something unprecedented. Another fact that All Things D said was new that hadn't been released before the trial was Apple's insane marketing budget. So Phil Schiller took the stand and testified. And, Apple has spent millions in ad spending. And it says here that for the period when the first iPhone was released in 2007 until the end of fiscal year 2011, Apple spent more than $1.1 billion on marketing its iPhone and iPad devices worldwide. And it says here, Apple considered this to be somewhat of a gamble. And, I think Schiller testified that each iPhone that has come out has sold more than all the iPhones that had been models that had previously sold. So, okay, so this is like interesting stuff, but I don't think it's earth-shattering. I mean, I think it's interesting, colorful stuff that we like, but I'm not surprised by a lot of this. I mean, I think you could have fathomed a lot of this stuff just on your own. Well, and this brings me to my next point, which is Cult of Macs writer Mike Elgan, who's on Google Plus a lot. Now, I really admire him. I think he's a great writer, and I really like his writing. But he came out with a post yesterday entitled, "Why Apple is Losing the Samsung Lawsuit So Far." Now, and I got attracted to this article because I was like, what do you mean they're losing the lawsuit so far? They seem to be winning the lawsuit. The judge got this, gave Apple this great ruling where the jury's going to be told that Samsung allowed evidence to be destroyed that was helpful to Apple. And you go to the article, and what Mike Elgan is talking about is he's making a big deal of the fact that, during the trial, a lot of information's coming about how Apple is operating. And he's, and I, on Google Plus, I said in a way that I think the headline is a kind of link bait, because the headline's not really about Apple winning or losing the trial, but rather that Elgan is saying that Apple's losing by allowing its secrets to come out during the trial. And he highlights 8 secrets. Now, some of them are the ones that I've already discussed, that Steve Jobs changed his mind about the 7-inch iPad, that Apple spent more than $1 billion on marketing the iPhone and iPad. But he had some other ones, that the code name for the iPhone was purple, and but he had some other things that he said came out to the trial that are damaging to Apple because they've become public. That Apple closely watches the competition, and he, apparently there was an email introduced during the testimony of Apple's industrial designer Christopher Stringer, in which he wrote, "Paul, I need your latest summary of our enemies for an ID brainstorm on Friday. If you have any more data beyond this, please could you update the chart? I wonder if there's anything worth noting about the Hewlett-Packard Palm leak," end quote. So he touches on that, and he also says that, testimony came out that Apple listens to its customers, and that there's extensive surveys of customers by Apple, and that, Samsung was trying to make that stuff public. And also that it came out that most people who buy iPhones buy iPhone cases, that 78% of iPhone owners buy iPhone cases, and that Apple thought about adding a kickstand to the iPad, and that Apple made some prototypes that had a kickstand built in, sort of like the new Microsoft Surface is going to have, and that that Schiller revealed that the iPhone came about because Apple was interested in expanding into other markets, and they entertain the ideas of making a camera or a car. Now, Elgan, how do you pronounce his name? Elgan makes a big deal out of this, and he says, whether you agree with Apple's obsession with secrecy or not, that obsession exists, keeping these secret is important to Apple, which is why the lawsuit has thus far cost Apple far more than Samsung. And I think this is crazy stuff by Elgan. I mean, this stuff is so not interesting or a big deal. And also the average consumer who doesn't obsess over Apple or the trial is never even going to know about this or really care. And I think Elgan, I think this is, link bait. Sorry, Mike. I mean, it's not about Apple losing the trial. And the thing is this, Apple has in-house attorneys and two big prominent law firms representing it, Morrison Foerster and Wilmer Hale. And I'm sure Apple's executives, including Steve Jobs when he was alive, because this lawsuit was filed when Steve Jobs was alive, sat around and discussed that if they sue Samsung, a lot of stuff is going to become public and made available in discovery. That's the nature of civil litigation. Apple knew full well what it was getting into. And this stuff is not a surprise. I mean, the customer surveys, if you've been an Apple customer like I've had for years, I've been subject to surveys. I've gotten all sorts of surveys from Apple over the years after I've bought something, multiple choice questions. And I've gotten multiple choice questions that were very lengthy from Apple. So I know that Apple's conducting a survey. And at this time, the fact that Apple is going to be doing a 7-inch iPad, well, that's already been, pretty much leaked to the public by Apple to the Wall Street Journal. And frankly, what's interesting? I think, isn't it interesting that a couple of weeks ago, Wall Street Journal and Bloomberg started reporting that Apple's going to release a smaller iPad? Maybe Apple purposely leaked it because they knew this internal email stuff was going to come out in the trial, because they knew when the trial date was. And I bet you Apple leaked it ahead of time to control the story. But the point is, how does this damage Apple? It doesn't. There's no, this. In fact, it only builds on the mythology. The fact that they had some purple project code and that they were sitting around in this, they put together this special team only recruiting the best at Apple. That fits in perfectly with Apple mythology. I mean, that's the whole history of how the Macintosh was created, by having this the pirate flag fly over it. And in fact, it perfectly fits with the whole mythology of Steve Jobs. Other stuff, the fact that it watches the competition. Of course they watch the competition. What major company that's competing doesn't watch the competition? They watch the competition, but they do their own thing. And as for the marketing, I don't think $1 billion in marketing over 3 years is that big a deal for a company the size of Apple. Frankly, that Apple's doing marketing. Just look at any billboard in any major city. Like in New York, there are huge billboards all over the place touting the iPad and the iPhone. Lots of telephone booths and subway signs have the iPhone or iPad. And this is all over the country. And obviously it costs a pretty penny to get that kind of advertising. And then when you look at the TV advertising, there's lots of TV ads for the iPad and the iPhone, and this exists all around the world. So $1 billion over 3 years in advertising is not big at all. Other stuff that he was making a big deal, that Apple had all sorts of ideas regarding what the iPad would look like. Of course they're going to kick around different ideas. I'm sure they sit around and think of a zillion different ways to make stuff. And of course they've considered going into the camera market or the car market. Apple used to be in the camera market. Back in the 90s, one of the first digital phones that ever, cameras that ever came out was an Apple camera that Apple made, Fuji made for Apple. So Mike Elgan, I don't know. I really think you're off the mark here. Apple carefully calculated whether it should go for a lawsuit, and obviously it figured this stuff isn't really that big a deal. So I think I don't know. I just very much disagree with his post. Now, what is interesting is that Apple did really go through all sorts of designs, and that's not a surprise because if you're trying to reinvent a phone and a smartphone, you're going to go through all sorts of designs. And looking at a lot of the slides that have been introduced in the trial of the prototypes that Apple had all sorts of designs, including designs where the iPhone was much more of a square device without rounded corners. Also a design where there was sort of like a hexagonal, sort of design, not a rounded corner, but sort of, like cut off triangles. So obviously Apple went through a lot. I mean, the designs of the iPhone were, I'm sure, all over the place. Also the same with the iPad. At one point they considered a kickstand. What else? They considered a much longer form, not the sort of, the more smaller rectangular form we have now. I mean, the kickstand, we know that Microsoft is going to do that with the Surface. So, they're just all over the place, the designs that Apple has in the past considered, and so the point, I think this helps Apple because Apple's point is, look, there are many different ways to design devices. And so Samsung didn't have to copy this way. And the fact is that Apple could have thought of like zillions of different ways to design this. In the end, chose one way. And, how is it that the whole industry is copying that one way? Because just look at all the different ways that Apple, if you're looking at the video version of this, all the different ways that Apple has created different slides. It's really tremendous. There were squares, there were all sorts of edges, thicker iPads, squarer iPhones, all sorts of designs. So I think I don't know. I have a feeling that there's a good chance Apple's going to win this lawsuit. Now, other big news this past week was something that came out on Monday, a website called iMore, which has a writer named Rene Ritchie, came out with news that Apple has an event planned for September 12th, and that the iPhone 5 release date is September 21st. And this is big news. It says that iMore has learned that Apple is planning to debut the new iPhone at a special event on Wednesday, September 12th, with the release date to follow 9 days later on Friday, September 21st. It says this information came from sources who have proven accurate in the past. And it says also that the iPad mini will be announced at that same September 12th event, as will a new iPod Nano, and that they haven't heard for a new release date for the iPad mini. It's according to iMore, but it could be the same as the iPhone 5. And so apparently a lot of people think this is definitely going to happen. iMore has had a good track record in the past. And Jim Dalrymple of The Loop, he confirmed yep. And yes, he confirmed yes regarding the September 12th event, and he's generally very hooked in. And The Verge, The New York Times, and Bloomberg, and Reuters, who are all, very reputable, also confirmed that they had heard this past Monday, July 30th, that there's going to be a September 12th event. So this is big news, and what's interesting is this. The event seems to be moved up a bit from when it was held last year. Now, if you remember, last year's event was held on October 4th, and the next day Steve Jobs died, and that was the date that the iPhone 5 was introduced. And this one's being introduced on September 12th, and actual iPhones may be sold on the 21st. Now, I'm thinking about this, and this is significant also from a financial performance point of view. And why is it significant? Because last year, the iPhone 5 was launched after Apple's fiscal quarter ended on September 30th. And I don't know if people remember, but Apple's performance for the quarter ending September 30th last year was short of analysts' expectations. And that's because the iPhone prior to that time had always been sold in that quarter ending September 30th. It usually had come out in June or July. And so you didn't have a huge surge of iPhone sales in that quarter. And I'm wondering if Apple moved up the event so that it could start selling some new iPhones in September to help the September quarter perform better. Because you can imagine if the iPhone 5 is being sold on the 21st and the iPad Nano, it helps even up Apple's huge surge of sales from new products over 2 quarters. Because although there's only, 9 or 10 days worth of sales in September, 9 days of sales in September, you've got the 21st through the 30th, that there's going to be huge selling on those days. In the first 10 days that the iPhone 5 is launched, there's just going to be record sales. It's going to be in huge, huge demand. And also for the iPod and for the iPad and for the iPad Nano, there's just going to be a huge number of sales. But it's towards the end of the quarter, so it helps Apple have a better quarter than if it saved all this stuff for October. So I bet you, because if it came out in October, it was only, all this big new product is only going to be really impacting the launch the quarter ending December 31st. And last year, Apple had a tremendous, one of the most gargantuan financial results ever for its quarter ending December 31st. And why was that? Because the iPhone 4S came out in that quarter. So I think Apple, I wouldn't be surprised if in terms of internal planning, Apple's Tim Cook and its financial people said to the team, look, we really should maybe try to get this launched in September so that we spread the huge bonanza of sales from the launch of the iPhone 5 and the iPad mini in not just 1 quarter, but 2 quarters. So by putting it at the very tail end of the quarter ending September 30th, it will help that quarter. But also, obviously, the biggest quarter is going to be the quarter ending September 31st. So, I'm excited. I think this is going to be huge for Apple. I think it's going to be, it's going to be a big home run. Now, there have been some leaked pictures of what the next iPhone 5 is going to look like. And late last week, a website called eTradeSupply.com on its blog posted some pictures of the screen and of the iPhone 5 and comparing it to the iPhone 4S. And these are parts that it claims it got, including the glass lens. And so basically the iPhone 5 is going to be longer. So the screen, instead of being 76.65 millimeters in length, is going to be 90.25 millimeters in length. So it's not a lot longer, the screen. And the diagonal, instead of being 3.61 inches, which is the current iPhone 4S, it's going to be 4.065 inches. So we're looking at a tad longer iPhone. Not crazy longer. And I think it didn't, but interestingly, it's not really wider. It's still only 51.60 millimeters wide. And the LCD screen is a little smaller, and the glass is in the resolution of the glass is going to be a little different. And apparently the material for the iPhone 5 glass lens remains the same, it says here, as the iPhone 4S, but it's going to be thinner. So it's going to be a thinner. And also, they tested it in the video that they did, and it appears to be more scratch resistance. And also, the camera is going to be aligned a little differently, like above the earphone. So, it's a little bit differently designed. So this is an interesting website, and macrumors.com also linked to them. So what do I think of this new design for the iPhone? Well, I think it makes sense, because one of my concerns is I don't want the iPhone to be wider, because I have average size hands, and right now when I hold it, I can reach with my thumb from one side of the iPhone holding it to the other. And if you make it wider, you're not going to be able to tap out with one finger, your thumb, on the keyboard. And I think a lot of people navigate on the iPhone using just one thumb holding it in their hand and not two. On the other hand, by extending the length in landscape mode, you can have sort of native size video in terms of whatever it is, 9:5, and you have a little more space. So, and the design isn't radically different. I mean, I think one thing that everyone has already confirmed is that there's not going to be traditional USB proprietary dock. It's going to be smaller. And that makes sense, because frankly, I think it's too big. A lot of junk gets in there, like lint, and I'd like to see it smaller. And apparently Apple's going to have like an adapter. Now, one thing that kind of annoys me is the following. Now, over on the Twit network, I was listening to Leo Laporte, I think on MacBreak Weekly, or the Twit, the Twit podcast. And Leo Laporte was sort of ragging all over, what could be the next iPhone 5. And he was saying that, Apple's like fallen behind. And he was mainly basing it on that the design of the iPhone 5 in terms of the leaked pictures show that it's roughly maybe the same sort of physical design, but like a little thinner and maybe longer. And he said basically that this is boring, that, Apple's fallen behind Samsung and all of Samsung's interesting phones. And I think, I don't know what Leo Laporte has with Apple. It could be, Leo Laporte has sort of been banned, I think, by Apple from going to those events, because a couple of years ago he was taking like video, live video shots from like an Apple event. But he seems to lately be just sort of ragging on Apple a lot. And the thing is, I think he's totally missing it. The iPhone 4 and the 4S are beautiful designs. They're highly successful. And Apple's not going to tweak it too much radically. Apple's going to make it maybe a little thinner, a little longer. But the design is a classic. And what's more important than the design is going to be things like, the metal that you use, or the glass that you use, or the screen quality, or, making a better camera, or the operating system. And you're not going to make a radical change to it, because you're not going to come out with multiple different styles of phones. You're not going to deal with that. And they've already shown the great success of the iPhone 4S. And so I think what Apple's going to do is refine it, make it thinner, make it lighter, make it longer, and give it things like LTE. I mean, a lot of people are going to upgrade just to get the faster cell phone data connection in it. So I don't understand why he's poo-pooing the iPhone 5. Apple's not going to make it like this big fat Galaxy Note or the Samsung stuff. Apple's going to go its own way. And frankly, this design that Apple has with the iPhone 4S is kind of a classic. It looks very elegant. I like how it doesn't have the curved back. It's also allows it to fit into many different things. So, I think, Leo Laporte, you're wrong. Apple's not losing its way. Apple's actually doing really well. Its stock price is again kissing its all-time high. It's bounced back from that supposed quarter miss, and it was last trading at 615. So, anyways, I'm excited. I'm definitely going to be upgrading, and I think a lot of other people are also. Okay, so that's it for episode 124 of the Apple Podcast. This is Lex at maxfuture.com. Thanks for listening. And again, you can help out this podcast by giving it a positive review in the iTunes store, or go to YouTube and follow me on YouTube or Tumblr or any other place that this podcast is listed on. So thanks for listening, and see you next week.
This has been a Max Future production.